Good morning. My name is Karen Cocq, and I am here on behalf of the Migrant Rights Network. We are here today to send a message directly to members of Parliament, particularly those who sit on the Standing Committee for Public Safety and National Security, who will be voting tomorrow on Bill C-12, the Strengthening Canada's Immigration System and Borders Act, soon to be followed by a final vote in Parliament. Our message today is simple. Bill C-12 cannot be fixed and must be withdrawn. Bill C-12 proposes changes to 9 pieces of legislation, is 70 pages long, and yet has only been given 3 weeks of study. During that time, no migrants who would be impacted by C-12, who could have their permits canceled or their refugee protection denied, have spoken to the committee. We were here less than 6 months ago to share the concerns of over 300 organizations from across all sectors of civil society about the original form of legislation when this government tabled it in June. Since then, that list of groups opposed to this legislation has only grown. And yet the government's fast-tracked deliberations have shut out all but one of them. Dozens of groups, many of whom have cross-country reach and represent hundreds of thousands of people, applied to speak before the committee to this bill and were denied. Meanwhile, MPs heard repeatedly from border and policing agencies. The government has said that C-12 will strengthen Canada's immigration and borders. But on the contrary, it will only add to delays and backlogs, undermine due process, and multiply the likelihood of discrimination and violations of human rights by introducing precisely the Trump-style policies that Prime Minister Carney said he was against and that the majority of Canadians revile. A few months ago, the Conservative government in Ontario passed a regulation similar to C-12, giving the government the power to cancel immigration applications en masse. Last week, 2,600 people, welders, telecommunication engineers, software developers, and construction workers, had their applications returned. Many of them had already been approved for permanent residency. They were given no reason, they have no means to appeal, and their work permits are about to expire. This is the power that C-12 would give the government. Mass discrimination powers, doubling down on a racist attack on migrants and refugees, and a deadly approach to drug policy that are based on politics and not facts. First, we will hear from Gauri Sreenivasan, Co-Executive Director of the Canadian Council for Refugees.
Good morning. Bonjour. The Canadian Council for Refugees is the leading national voice on refugee policy in Canada. We represent over 200 frontline refugee-led and allied organizations across the country. We are deeply concerned with both the clear intent and surely the unintended consequences of Bill C-12. We have asked to appear before the parliamentary committee studying the bill to share our insights. We have been shut out. Nous sommes ici aujourd'hui aussi près que possible du processus parlementaire pour lancer un appel au gouvernement et aux partis d'opposition qui dominent le processus afin qu'ils ralentissent et examinent les implications de ce projet de loi. This bill claims to be about enhancing public security and tightening the efficiency and integrity of the immigration system. But C-12, in fact, proposes a radical overhaul of our current refugee protection regime with measures that will undermine procedural fairness and fail Canada's obligations under domestic and international law. Ironically, while C-12 proposes roadblocks to prevent refugees from accessing Canada's current system for adjudicating claims, a system that is the envy of the world, it simultaneously creates ineffective and duplicatory structures to assess those same claims at the IRCC while generating new backlogs both at the Immigration and Refugee Board and the Federal Court. The incoherence is concerning. The bill will increase costs. It will put thousands in limbo without status, driving them underground, and it will risk lives by vastly increasing the likelihood that a refugee could be returned to face the persecution that they flee. Women, gender-diverse individuals, and survivors of gender-based violence will be some of the most negatively affected. A rigid one-year timeline to make a claim is being proposed. This timeline punishes these populations who require time to deal with trauma, to escape abusers, to gather evidence while trying to navigate significant financial and other barriers. Unaccompanied minors or those whose country conditions change, all declared ineligible after an arbitrary 1 year. International human rights law is clear. Your right to seek asylum is not subject to how you arrived or when you came. When you cross borders, your rights come with you. Full stop. The takeaway here is this. You cannot weaken the core safeguards of due process in a system where lives are at stake. Decision makers make mistakes. You need checks and balances. Canada receives less than 2% of claimants around the world, and we have a world-respected institution purpose-built to hear these claims. Close to 2/3 of those whose case is heard were found to be refugees last year alone. Those who are not are turned down. What is the problem that we are trying to solve? The bill reflects a dangerous turn towards a US-style immigration and border extremism. In Canada, we reject those who use divide and conquer tactics to turn us against our neighbors. We are proud to be a country that welcomes refugees, and we expect our leaders to carry on that legacy. C-12 does not honor that commitment, and it takes our country in a direction that no one asked for. The bill should be withdrawn in its current form. Call now on Tonny.
Thank you so much. Good morning. My name is Tonny Muzira, and I am from the Center for Black Development Options Canada, a nonprofit organization started by refugees, working with refugees and immigrants to ensure that they live a dignified life.
Gone on mute, Tony.
Sorry, I'm just here to give a lived experience as someone who came here as a refugee. And I'll talk about and standing in solidarity that the 1 year bar is deeply harmful measure that is incompatible with Canada's commitment to human rights. It prevents anyone in Canada for over 12 months from making an asylum claim, regardless of the circumstances that delayed the application. It effectively ignores the profound realities that prevent timely claims, such as trauma, mental health struggles, homelessness and poverty, misinformation, and language barriers. The immense effort required to simply survive the first year in a new country. And as I speak from my personal experience as a refugee who was given protection 2 years ago, and through my work at CBDOC, I have seen countless people who fled persecution and endured unimaginable trauma, wait years for protection, often arriving through a G7 or 5I countries because it was their only viable route. Their delay was not a choice, it was a consequence of complex systems and circumstances beyond their control. Bill C-12 would punish these vulnerable people for delays that they could not control. It would take away their right to protection entirely, telling them that Canada doors are closed because of the route they took. This is not just a policy, it's people's lives. We cannot turn our backs on those seeking safety and dignity. Let me be clear about the devastating consequences of this measure. Claimants are denied the right to even ask for protection. They are refused legal aid, settlement services, basic supports. They live in constant fear of removal, making any interaction with authorities, landlords, or hospitals terrifying. They are excluded from housing programs, making homelessness almost inevitable. They are parents and children surviving overcrowded rooms or depending on strangers. They are forced to carry their trauma without being allowed to explain their need for safety. Furthermore, Bill C-12 expands ministerial discretion, reduces access to full hearings, and introduces retroactive measures that disproportionately impact Black and racialized migrants, deepening existing inequities in housing, employment, and policy. Behind every policy is a human life seeking safety, not punishment. Today, I urge Parliament to act with fairness and compassion, remove the 1 year asylum bar entirely, restore access to full and fair hearings for all claimants, ensure national security measures do not override human dignity. Canada must not deny protection based on arbitrary deadline. Our laws must reflect our fairness, justice, and humanity. Lastly, I want to say that this bill impacts the voices that was not consulted. People were not consulted. Most of us of refugees were not consulted about the bills, and we feel it's important that the bill is removed in all its entirety. Thank you so much.
Thank you, Tony. Next, we will go to Louis-Philippe Jannard from the Table de concertation des organismes au service des personnes réfugiées et immigrantes, and with the Front commun québécois contre le projet de loi C12, who will be speaking in French.
Merci, Karen. En raison des nombreuses attaques aux droits des personnes réfugiées et immigrantes qu'il contient, le Front commun du Québec contre le projet de loi C12 exige le retrait du projet de loi à l'instar de centaines d'organisations à travers le Canada. Parmi ces attaques, C12 prévoit entre autres la création de nouveaux pouvoirs discrétionnaires qui donneraient au gouvernement un immense contrôle sur la vie des personnes migrantes. Ainsi, le gouvernement aurait la possibilité de suspendre ou annuler en masse des demandes ou des documents d'immigration pour des catégories entières affectant potentiellement des centaines, voire des milliers de personnes, y compris des personnes qui vivent au Canada et qui font partie de nos communautés. Ce pouvoir s'exercerait par l'adoption d'un simple décret par le Conseil des ministres, autrement dit, sans aucune forme de contrôle par le Parlement ou par les tribunaux. Les personnes affectées n'auraient ni l'occasion de faire valoir des considérations personnelles, ni accès à des mécanismes d'appel, en contradiction totale avec les principes de justice fondamentale. La seule contrainte prévue est que ces mesures se fassent dans l'intérêt public, une notion extrêmement floue que le gouvernement a affirmé ne pas vouloir définir afin d'avoir plus de flexibilité. Cela nous inquiète particulièrement dans le contexte actuel où les discours racistes et xénophobes se multiplient. On craint que, comme par le passé, des groupes entiers souffrent des humeurs politiques du moment. En effet, on n'a pas vu de tel pouvoir dans les lois relatives à l'immigration depuis les années 70, lorsque la loi fédérale a été modifiée en profondeur afin de tenir compte de nos obligations internationales en matière de droits humains. On assiste ainsi à un grave recul qui nous ramène à une époque qu'on pensait révolue, celle où le gouvernement pouvait adopter des mesures ouvertement discriminatoires à l'aide de simples décrets. C'est avec de tels pouvoirs qu'au début du 20e siècle, le gouvernement a empêché l'arrivée d'immigrants indiens ou japonais. C'est avec de tels pouvoirs qu'en pleine crise économique des années 30, le gouvernement a déporté des personnes qui militaient pour les droits des travailleurs ou des personnes qui avaient simplement perdu leur emploi. C'est avec de tels pouvoirs qu'en 1938, le gouvernement a refusé que les passagers de confession juive qui fuyaient la persécution nazie à bord du MS Saint-Louis puissent trouver refuge au Canada. Avec de telles mesures, le projet de loi C12 nous ramène plus d'un siècle en arrière à des moments de notre histoire qui aujourd'hui nous font honte. Rien ne pourrait rendre ce projet de loi acceptable. Il doit être retiré. Merci.
Merci, Louis-Philippe. Next, we will hear from Tamir Israel with the Canadian Civil Liberties Association.
Thank you. In addition to the reshaping of Canada's the problematic reshaping of Canada's immigration system that my colleagues have highlighted, Bill C-12 also provides broad authority to share immigration information. Any information can be shared within IRCC with minimal limitation. This can fuel the adoption of problematic AI tools in immigration assessment, a process that is already underway and has already caused issues in processing applications fairly. Immigration officials will also be authorized to share some types of data, including sensitive information, such as refugee status and changes in gender identity, with any federal, provincial, or municipal entity. This includes political staff, social service providers, public power companies, housing authorities, security agencies, and police. Subject to minimal additional restrictions, federal, provincial, or municipal entities can even be authorized to share sensitive information with foreign officials. The authorization fails to include baseline privacy safeguards, such as the need to ensure information is only disclosed when it's necessary and proportionate to do so. Disclosing this type of sensitive information with few limitations places people at heightened risk of danger, can expose them to discrimination, harassment, or violence in Canada, and can jeopardize their access to housing, healthcare, or employment. We urge the government to reconsider this proposal and withdraw Bill C-12.
Thank you, Tamir. Next, we will hear from Nick Boyce with the Canadian Drug Policy Coalition.
Good morning. We are calling for the immediate withdrawal of BC 12. No amendments can fix a bill on fundamentally flawed assumptions about illicit markets, public safety, and human rights. We echo the serious concerns raised about migration, information sharing, and human rights. From a drug policy perspective, BC 12 doubles down on exactly the approaches that created and helped sustain Canada's toxic, unregulated drug crisis, now killing more than 20 people a day. C12 expands accelerated precursor scheduling, despite decades of evidence that prohibition does not reduce the availability of illegal drugs or address demand. When governments ban drugs or the chemicals used to make them, producers simply adapt, finding ways to avoid the controls or creating new synthetic drugs with unknown health risks, making the drug supply more volatile and often more potent. These shifts have directly driven the rise in drug-related injuries and deaths over the last decade. Heroin prohibition has incentivized illegal fentanyl. Accelerated scheduling under C12 will only speed up this dangerous cycle, pushing the market toward even more unpredictable drugs. BC 12 also gives the Canadian Coast Guard a security mandate, with no clear costing, no public health rationale, and no clear safeguards on how intelligence will be shared with the United States. This is happening while the U.S. is violating international law for bombing civilian boats in the Caribbean and Pacific, killing dozens during supposed drug control activities. Canada must not be complicit in actions that breach human rights and violate international law. This expanding enforcement strategy also comes with huge and growing fiscal costs. As organized crime adapts and synthetic drug markets evolve, investigations and prosecutions become more complex and enforcement budgets balloon. Meanwhile, health services and social supports, measures that actually reduce drug-related harms, face significant cuts. This is the opposite of evidence-based policy. The evidence is clear. Prohibition causes more harm than it prevents. Legal regulation allows us to control quality, set product standards, restrict sales and access, reduce the power of organized crime, and increase public health and safety. We already do this with alcohol, cannabis, and pharmaceuticals. We can learn from these different models. Bill C-12 takes Canada further away from that future. It entrenches the very policies and systems that have driven harm for decades. Canada does not need more of the same. We need new approaches grounded in public health, human rights, and evidence, not fear, punishment, and militarization. BC 12 must be withdrawn.
Thank you. We'll now move to questions.
From the Canadian Press, just get the kind of recorder reset up here. All right, that's been an issue. But yeah, just you talked about trying to get before the committee. Can you tell me a bit more about the efforts there? Are you reaching out directly to specific MPs on the committee, or how is that process working, and what were you hearing back from committee members?
Mm-hmm. As we are here as part of a cross-country network of organizations that has come together to oppose C-12, and we've been meeting regularly and sharing information and strategy, and across all of our organizations we have made individual attempts to communicate with MPs on both the Immigration Committee and the Public Safety Committee that our organizations have relationships with. We also, the vast majority of the groups in this network, which is over 70 organizations, applied to speak before the committees, both committees, and none were accepted. And we, dozens of the organizations part of this network submitted briefs first to the Immigration Committee and now to the Public Safety Committee. But on this accelerated timeline, there is absolutely no way that the MPs on the committees have been able to read any of the information that all of these leading advocates and expert and directly impacted voices have shared. I don't know if anybody else wants to add to the process part.
I'll just say that there are, I think, some members of Parliament that have concerns. We have been able to have some individual meetings. What is not clear is whether those concerns will find their way to challenging the legislation, to making any amendments. Of interesting note, the Immigration Committee just finished a very rapid set of hearings and sent a report to the Security Committee, which meets tomorrow, the Public Safety Committee, And the report is devoid of content. So it just says we had hearings, and these are basically the groups that we met with. So it remains to be seen to what extent the parties in the House of Commons will register the concerns that have been expressed. But the process feels both rushed and closed, because there is no way to either see the impact of the briefs you have submitted or the meetings you have had, and certainly there has been no opportunity to present, to be able to engage in dialogue with the committees who have been tasked with studying the process.
I just want to follow up on something you said there, and saying you've heard concerns more privately from some MPs. Would those be government members?
We've actually, we have members in the coalition from across the country, and so these organizations, our organizations have been meeting with Liberals, with Conservatives, with Green, with the NDP, and with the Bloc Québécois as well.
Like just like people who've been saying like specific concerns with the bill. Are these committee members? Are they like other MPs who are? They
are MPs from across basically all party lines, and both on and off the committees.
And just a big difference with committees this year, of course, since they don't have recognized party status, no NDP members. Do you think you would have been able to get before the committee if there were NDP members on either the Immigration or Security Committee?
Normally, what happens is that an MP on committee can actually put forward a list of witnesses that they want to have called. That was even the case with at SIM and at CQ this time around with the study of Bill C-12, and MPs, including Liberal MPs, put forward lists of witnesses that were not called. So normally, yes, I would say that had the NDP had a seat, that may have increased the chances that any number of these organizations may have been called to appear. But in this particular process, I doubt that even would have been the case, as the process was so swift, so rushed, and so narrow.
Of course, tomorrow we do have the clause by clause, as we mentioned already. Michelle Rempel-Garner last week was talking about a list of amendments she plans to bring forward, such as barring asylum claims if someone first transited through an European or another G7 nation. A few other things here and there, like denying social services to people who have removal orders beyond emergency medical care. What do you make of the amendments that Ms. Rempel-Garner plans on bringing forward tomorrow?
The amendments that MP Rempel-Garner have put forward, like any of the comments that have been made by Conservatives in the committee, but including any of the comments made in the media over the course of this process when C-12 has been introduced by the government itself as well, all really rely on this notion that A, the immigration system is somehow broken, and B, that the fix to it is to expedite the shunting of people's access to due process. And we take issue with both of those questions, and particularly to say around questions of the asylum portions that are included in C-12, yes, we disagree with the one-year bar. There is no timeline that would be fitting for a refugee claim, and that is why there are no timelines that are set, for example, in international refugee law. There have been multiple legal challenges in Canadian courts to the Safe Third Country Agreement with the United States, adding to the list of places where refugee claims can simply be thrown into the garbage. It does not address that issue of whether or not these blanket decisions and blanket rules around entire groups of people that are not to be permitted access to due process or are not permitted the right to be able to appeal or to have an individualized assessment, whether it's with permit cancellation or with refugee claims, this whole notion that entire groups of people can have a blanket ban from the system, it challenges the basic notions of fairness, and we believe would be in violation of the Charter of Rights and Freedoms, and would be subject to legal challenges like the designated country of origin list was under the Harper regime, like the Safe Third Country Agreement has been. So we challenge this notion that by blanket banning and punishing entire groups of people based on who they are, is a solution that anybody in this country wants.
Yeah, thank you, Karen. I just want to add First of all, we would welcome an opportunity to meet with the immigration critic from the Conservative Party. Have requested and have not had the opportunity yet. It's not, we haven't seen the detailed amendments. We've seen a lot of discussion in the media, and it's not clear at all what the intent of those amendments are. There are quite a few contradictions. I would say that on healthcare, the Conservative Party is proposing measures that they already tried to introduce in 2012 to strip refugees of health care, certain categories of refugees of health care. And they are measures that Parliament, including the Conservative Party, knows full well the courts have rejected. They are measures that Canadian doctors have rejected. They are measures that Canadians have rejected. The federal court ruled in 2014 on this exact type of amendment that cuts to the interim federal health program based on category of who gets access, constituted, and I quote, cruel and unusual punishment, and that it breached equality rights protected under the Charter for refugee claimants. The court found that denying basic life-saving health care to impoverished migrants shocks the conscience and outrages Canadian standards of decency. So currently, the Conservative critic is claiming that they have concerns that C-12 may backlog the courts, and yet they are throwing out ideas that they know have been declared illegal, that they know Canadians and Canadian doctors have opposed. We hold healthcare as a fundamental right in this country, and so pretending that they will be able to pass an amendment to strip some of the most vulnerable people of those rights is frankly an abomination. It's not sure if they are thinking that Parliament won't remember or that the public won't remember that we have tested these types of exclusions before and resoundingly rejected them. But it's a cheap shot. And frankly, it distracts attention from the real dangers in this bill. The measures also are using specific language about good refugees and bad refugees that the court instructed in its ruling are actually dangerous because they perpetuate stereotypes and discrimination. And at the same time, the party is saying that they have concerns that immigrants shouldn't be blamed. And so they're playing a kind of a dangerous narrative, which we feel needs to be clearly rejected. It's an approach to dealing with immigration and refugees that is not what we want, not the direction we want to go in this country.
And just some questions for Tonny as well too. Apologies if I just missed this in your remarks. You mentioned coming to Canada as a refugee. Where did you come from specifically, and what year, and how long before you applied to be a refugee in Canada?
Yeah, thank you so much. I came in Canada in 2022, and I was approved protection in November 2023. I came from a country called Uganda in East Africa.
And just for the background as well too, lots of issues in Uganda, but just can you tell us a bit about just your story of like why you came to Canada and just how you came here?
Thank you so much for that question. Yes, I came to Canada because of a lot of human rights violations in Uganda, most especially against LGBTQ rights. There was a bill that was passed in 2023, and in Uganda was doing a lot of human rights advocates fighting for LGBT communities being affected and also being part of them. So it's one of the reasons why I had to leave and come and seek asylum in this country. Fairly enough, I was able to be, granted protection in a period of 12 months, which is not happening one of these days.
Just on the the 12-month rule the government wants to bring in here, just based on your story, it sounds like your application got in within your first year here in Canada. But how widespread, in your experience, or like open to anyone else here, really, would you say applications for refugee status are more than a year after somebody comes to the country?
I would say, before they were actually, to some extent, within our period of time when we came in 2023, we had a mass majority of refugees between 2022 and 2023. Remember 2023, we even had a housing crisis because of refugees in Toronto. But what I can say is that most of these decision makers involved in crafting this bill do not understand what it means to be a refugee. I can tell you now for a fact that if this bill is passed into law, even the processing times are gonna increase. For instance, I'm not sure when I'm gonna be approved for permanent resident. It might even take 10 years. So we don't know if this bill is passed. Even the refugee asylum seeking process might even increase. It can even take 2 to 3 years. So someone comes in here, they're seeking for safety, they're seeking protection, and they don't know exactly when they're going to get status, which is really one of the things I mentioned in my initial submission, that it's going to bring in issues of mental health, it's going to bring in issues of trauma, it's going to bring in issues of poverty and homelessness, because you don't know where you're going to go, you don't know what your status stands while you're seeking safety in Canada.
I think Gauri wanted to respond to that one, David.
So it's impossible to predict in the future how many people would exactly be affected, for example, by the one-year bar, but it is important to think about the categories of populations who would be ineligible. And so if you think about anyone who has been in Canada longer than a year after June 2020, this could include, for example, both a student who has been here for a few years studying, but it has taken them some time to put together both the courage and the sense of safety to ask for refugee protection on the basis of LGBTQ orientation. Women fleeing domestic violence are almost always, their cases almost always take longer than a year because they need to extract themselves from their abuser. They are usually second in line as immigrants for access to language training, for supports in their family. It takes them much longer than other members to be able to feel both that they understand that in Canada, and hopefully until this bill, gender equality matters, women's rights matters, and that actually persecution on the basis of violence against you as a woman is in fact a refugee claim, and to put together in the context of this trauma the documents required for their case to find a lawyer. So our members, like the Barbara Schleifer Clinic, who only deal with victims of gender-based violence and domestic abuse, say that all of their clients, it always takes them longer than a year before they are ready and feel safe enough to be able to make a claim. Or in a context where somebody's country situation changes, they've been in Canada with a work permit, even with the intent to go back, and the regime changes or the laws change, and suddenly they have become persona non grata. We've just seen in a country like the US overnight, someone who is trans can be declared to not exist anymore. So the thousands of people that could be affected are very concerning. And the other place where I would identify the changes relate to the fact that those who don't qualify because of the one-year bar have access only if they can be removed to this thing called the pre-removal risk assessment. There are already, we can see in Canada, growing cases, but thousands who will neither be able to access a refugee claim or be able to be served this kind of second lower quality process under the pre-removal risk assessment because they cannot be removed to their country of their origin. Think Afghanistan, think Haiti. And so the bill actually will create thousands of people without status at all. We noted even, for example, in the UNHCR's testimony before Parliament, that they've identified the numbers of acceptance that needs to be accounted for in the bill, that we need to have a hearing. So hard to predict the numbers, but it's important to think about the dozens of categories of people who, under no control of their own, are now at risk, and for whom the one-year bar is completely arbitrary. And just go back to repeat, under international law, there is no timeline on your right to seek protection. The thing that matters is, do you have a case? And for that, you need an independent process to assess the merits of your claim.
I'll just say one last point to that, David. On not just with the one-year bar, but also with the mass permit cancellation, the whole premise of these two elements in C12 is that entire categories of people can be suddenly decided that they do not have rights to stay in this country. And we challenge the very premise that entire categories of people can ever be told anything. And like Louis-Philippe said in his remarks, this harkens back to the 1930s, when people of Japanese descent, when people who were unemployed had their immigration status mass canceled. This harkens back to the MV St. Louis, when Jews fleeing persecution from Nazi Germany were turned away. This is what happens when the government has discretionary power to make decisions that upend the lives of entire categories of people based on who they are. It is racist, it is dangerous, it threatens lives, and we believe it will be challenged in court.
Thank you. This concludes the press conference. Merci. C'est ce qui conclut cette conférence de presse.
There are no questions online, I guess? The time is up.
Sorry to people online if I monopolize that whole thing.
It's okay, David.
Pretty sure, Nick is on there.
Oh, is he? Wow, he knows us all.